I forgot to record it. Now the presentation is being recorded. It'll be available for download at our website. If you have any questions during the program, we probably won't be able to take those during the program, but shoot me an email, and or you can use the chat function on the WebEx program, and I'll respond to your emails offline afterwards. Remember, when we're talking about the HIPAA stuff, we're not going to have time to go through everything in detail. I'm just going to give you some of the high points of what you need to do to avoid the penalties. So when it comes time to actually applying this stuff, make sure that you pull out the regulations and check the rules, or if you're not the privacy officer, that you check with the privacy officer. Remember also that the rules in the application may depend somewhat on the entity type. The rules are a little bit different if you're a covered entity versus being a business associate. Make sure that you're looking at the right rules that apply to your particular situation. Also, remember that HIPAA is the floor of patient privacy, but is not the be-all and end-all when it comes to patient privacy. To the extent that there is a more restrictive state law or federal law that's out there, you have to comply with that more restrictive federal or state law. For example, the federal rules concerning federally funded drug and alcohol treatment programs are more restrictive than HIPAA, so you would have to comply with those more restrictive laws. Finally, beware any state court cases concerning privacy. We're going to be talking today about the HIPAA privacy rules, but there is a growing number of cases that are out there where people are bringing private causes of action against healthcare entities because of privacy violations. Those rules are going to be governed by state law, and which really exists independently of HIPAA. I'll talk a little bit more about that later. For those of you who need to be oriented concerning the HIPAA stuff, just a real quick HIPAA background. We have different HIPAA rules. In 2003, the government issued the privacy rules, which require covered entities and business associates to protect the confidentiality of protected health information. It not only covers the confidentiality of those records, but it also gives patients certain rights concerning their information. We'll talk about that later. In 2005, we received the security rule, where the privacy rule applies to any type of protected health information, which is individually identifiable information concerning a patient's health, healthcare, or payment for their care. The privacy rule applies to any of that information in any form or medium, whether it's electronic, paper, videos, photos, whatever. The security rule, however, only applies to electronic protected health information and requires you to implement certain very specific policies and procedures to protect your electronic data. In 2009, we came out with the government came out with the HITECH Act, which imposed new requirements, dramatically increased the requirements for compliance. Among other things, it required us to self-report breaches of protected health information and impose some additional penalties for noncompliance. For several years, we functioned with proposed rules, but in 2013, we received the omnibus rule, which took all of those proposed rules, those standards that were set out in the HITECH Act, gave us a final rule. So now we have the final rules that we need to comply with. Hopefully, you're all complying with those new rules. If you have not done anything with your HIPAA policies since before 2013, your HIPAA policies are outdated, and therefore you need to make sure that you update them to comply with the new omnibus rule. I always like to talk about why you need to comply with HIPAA. If you're a business associate or a covered entity, you have to comply because of the penalties that are going to affect you. First, and perhaps the scariest portion of it, are the criminal penalties. A violation of HIPAA can actually result in criminal fines and penalties that can land you in jail. It applies if employees or other individuals obtain or disclose protected health information from a covered entity without authorization. That's very broad. The penalty depends upon the type of conduct involved. If you knowingly obtain the information in violation of the law, it's a $50,000 fine and 1 year in prison. On the other hand, if you do it with intent to sell, transfer, or use for commercial gain, personal gain or malicious harm, can be up to a $250,000 fine and up to 10 years in prison. Those are pretty serious consequences. HIPAA has been used to prosecute certain criminal actions, including identity theft and other actions that were taken involving protected health information. But what you normally have to deal with, the criminal cases out there are relatively rare, but what you really need to be concerned about are the civil penalties, because the HITECH Act increased the civil penalties 250 times what they used to be. Now, if you act with willful neglect, but you correct the situation within 30 days, you can get hit with a penalty of $10,000 to $50,000 per violation, or up to $1.5 million per type of violation per year. What's really scary is if you act with willful neglect, the penalty is mandatory. The OCR must come in and impose a penalty if you act with willful neglect. Now, if you correct it within 30 days, you can limit it to $10,000 to $50,000 per violation. On the other hand, if you fail to correct it within 30 days, then the government must impose a penalty of at least $50,000 per violation if you act with willful neglect, or up to $1.5 million per type of violation per year. That's pretty scary stuff. The good news is that only applies if you act with willful neglect. If you don't act with willful neglect, you can still get hit up with penalties of $100 to $50,000 per violation. But guess what? There is no penalty if you correct it within 30 days. Even if you don't, the OCR may waive or reduce the penalty so long as you don't act with willful neglect. So I am going to be telling you what you need to do today to make sure you are not acting with willful neglect. Now, the government has been very active in enforcing HIPAA compliance on some of their reported decisions. 2014 was a banner year for HIPAA penalties. Some of them are noteworthy. I'll talk about some specific ones as we go along. But when you look at the recent fines and penalties that have been imposed, the ones that have been announced, something is very noteworthy. It used to be when I talked about HIPAA, I really didn't focus too much on the security rule because the government wasn't enforcing the security rule. Those times have changed. The big ticket HIPAA items, the big exposure, are now breaches of electronic data. For those situations, the OCR is enforcing HIPAA with a vengeance, and those can result in multiple penalties. One of the reasons the electronic violations are so serious is that the sheer numbers of people who can be affected by them. If, for example, you lose a laptop containing 2,000 patients' information, according to the OCR, that's 2,000 separate violations. And if that violation occurred because you did not have appropriate policies or procedures that were in place under the security rule, for every day you did not have one of those policies or procedures in place, that is a separate violation. So the number of violations can rack up very fast when you're talking about security rule compliance. So if you have not taken the security rule seriously before now, it is definitely time to take it seriously. 2014 was a year of cyber attacks. Not only did you have the big Sony fiasco, as well as a bunch of other highly publicized cyber attacks, it also hit the healthcare industry. Just a couple of weeks ago, Anthem was hit by a massive cybersecurity breach. There's been a lot of chatter and a lot of buzz about whether or not the government ought to up the requirements for the HIPAA security rule to more clearly enunciate that we have to maintain encryption for security rule compliance. As we go forward in 2015, that's something to monitor to see whether or not there are additional changes, additional requirements that are placed on entities to comply with the HIPAA security rule. Well, that's all scary stuff, but again, the good news is that under HIPAA, it is an affirmative defense. HHS may not impose a civil penalty on a covered entity or business associate for a violation if the covered entity or business associate establishes the violation was not due to willful neglect, so you don't act with willful neglect, and you correct the situation within the 30-day period beginning on the first date the covered entity or business associate knew or should have known that the violation occurred, or such additional time as HHS deems appropriate based on the facts. That means that if you've done everything that you should in order to protect your people, and you just have a rogue employee that goes out and violates HIPAA, you may be able to avoid willful neglect. In the commentary that came out to the breach notification rule or the enforcement rule, the government gave the following scenario and concluded that in this particular situation, the covered entity did not act with willful neglect. This is the scenario they gave. A hospital employee accessed the paper medical record of his ex-spouse while he was on duty, knowing that such access was not permitted by the privacy rule and contrary to the policies and procedures of the hospital. That is a violation of the privacy rule, and therefore there was a privacy violation that could result in potential penalties. However, the government noted that the covered entity had appropriate and reasonable safeguards regarding employee access to medical records and that it had delivered appropriate training to the employee. Under those circumstances, under that hypothetical, the government said that would not be willful neglect. The key there is that the covered entity had done what it should have done in order to minimize the risk of those types of breaches. It had its policies and procedures in place. It had reasonable safeguards in place, and it trained its employee. Assuming that the covered entity also acted promptly to mitigate the effects of any breach, there was a very good chance that the government would come in there and say, hey, in that situation, yeah, the employee violated HIPAA, but guess what? We are not going to impose willful neglect sanctions on you, employer, because you did what you could do. That is not willful neglect. And as long as that employer corrected the situation within 30 days, that is an affirmative defense to penalties under HIPAA. Now, if those scary civil penalties and criminal penalties aren't enough to scare you into complying with HIPAA, there are some additional reasons. In addition to the feds coming after you, the state attorney general can also bring a lawsuit against you. They can get $25,000 fine per violation, plus they can recover their fees and costs. And some of those big ticket cases that have been coming down, several of them have actually been brought by the state attorney generals and not by the Office for Civil Rights. In addition, in the future, affected individuals will be able to recover a percentage of the fines or penalties. That was part of the HITECH Act statute when it was passed. Congress stated that HIPAA would allow individuals who were adversely affected by a breach to recover a percentage of any of those fines and penalties. Essentially, that creates an incentive for people to complain about HIPAA violations and pursue those HIPAA violations. Now, we have not received the implementing regulations concerning this rule. So this, even though it's in the statute, we don't have any regulations enforcing that yet. And when the omnibus rule came out in 2013, the government said that they would be coming forth with the regulations that were required by the statute. They're actually beyond the deadline for promulgating those regulations, but we have not got those regulations yet. I don't have a time frame on when we might expect those, but that's something that you'll want to watch for as we go throughout 2015. In addition, even if you're not worried about lawsuits by the federal government or these anticipated statutes or regulations that may come out, you got to be worried about your job, because under HIPAA, an employer has an affirmative obligation to discipline an employee who violates HIPAA. And if the employer fails to do that, that employer may itself be violating HIPAA. HHS is supposedly going to resume audits in 2015. HITECH Act required covered entities to be subject to audit by HHS. HHS had a pilot program that they did a year or two ago, and then they were going to come back and evaluate that. They were supposed to resume the audits in 2014, but that's been pushed off till sometime in 2015. We don't have the specifics about that, but just watch for that. The bad news is that they may catch you by these audits. The good news is it's really hard for, given the limited manpower, for OCR to audit the hundreds of thousands of healthcare providers who are actually out there. I think the latest version that I saw, the proposed audit protocol would be for they were going to audit 350 healthcare providers and 50 business associates. Now, the fact that the government's going to audit business associates, that's a new aspect of this. The prior audit program wasn't limited, or didn't include business associates, so you might have to watch for that, but the chances of you getting hit up by an audit are pretty slim. Significantly, the OIG is getting involved in HIPAA issues. Part of the OIG's 2015 work plan specifically addresses HIPAA issues, that the OIG said that they were going to start evaluating whether or not covered entities are complying with the HIPAA security rule, particularly the security rule governing contingency plans. If, for example, you have a crash of your system or some kind of catastrophic event occurs, they want to make sure that you've got the ability to continue to provide effective care and maintain access to records. The OIG is also looking at this in the context of the meaningful use rules, and therefore it may be that the OIG, you may not only get a call from the OCR, you may get a call from the OIG if you're not complying with the security rule. In addition to the federal government coming after you, there is an increased risk that you may actually get sued for a HIPAA violation in a private civil lawsuit. Now, HIPAA expressly stated that there is no cause of action under HIPAA, so they can't sue you. Somebody can't sue you under the statute. The statute does not grant somebody else a private cause of action against you, but a violation of HIPAA could still give rise to other civil lawsuits in other ways. For one thing, a covered entity, before it can disclose protected health information to a business associate, has to enter into a business associate agreement with that business associate. If the business associate violates HIPAA, then that covered entity would have a breach of contract claim against the business associate. So it could give rise to contract damages against the business associate. The thing that's maybe even more scary is that individual entities are convincing some state courts to allow them to sue for essentially what are HIPAA violations. They're either doing it under a common law negligence theory or a negligence per se theory. Under the negligence per se theory, the theory is this, that in order to be able to sue for negligence, you have to have a breach of a duty. And some plaintiffs' lawyers are coming in and convincing courts that, well, the duty is HIPAA. So if you are violating HIPAA, therefore, you are per se violating a duty that's owed to this particular patient, and therefore that patient can sue you not under HIPAA per se, but for a violation of the common law duties that you owe to that particular patient. And therefore, HIPAA may be used to establish the duty that is owed in a common law negligence case. We also see some privacy torts out there. Some states have specific torts that allow patients to sue for privacy violations, whether it's public disclosure of private facts or intrusion into the solitude or seclusion or infliction of emotional distress. Normally those require very significant emotional distress, pretty outrageous, unreasonable conduct, so you don't see those prevail very often. Now, those causes of action I just talked about are direct causes of action against the defendant because of what the defendant did. There's another theory out there called vicarious liability. This is the situation where an employer may not itself have been negligent or committed a tort, but the employer's employee committed the tort, and therefore the employer is vicariously liable for what that employee did. A very scary case came out just a few months ago from Indiana in which Walgreens was found to be vicariously liable for improper snooping that one of its employees did. Now, this is a situation where Walgreens apparently did everything right. It had the required policies and procedures in place. This employee violated the policies and procedures. Nevertheless, the Indiana Court of Appeals affirmed and said that employee was still acting within the course and scope of their employment, and therefore Walgreens, hey, you're liable for $1.4 million under Indiana law. Now, this actually was not a HIPAA case, and the opinion didn't cite HIPAA in it, but the fear is that this might gain some momentum in other states. This appears to be an aberration. Most states have not gone this far. There have been other decisions which are contrary to that. The bottom line, though, is you need to be very careful. Unlike the situation where we're talking about HIPAA penalties, if you're talking about HIPAA penalties, if you conduct the proper training, if you have the appropriate policies and safeguards in place, and you have a rogue employee that goes out and violates it, you can generally establish you didn't act with willful neglect, so you're not going to be liable for HIPAA penalties. But based on the cases like this, the state law cases, there is a potential that you could be vicariously liable. So maybe it's not only enough to make sure you have the policies and procedures in place to provide the training, but actually you need to make sure that your policies are effective, that you're actually stopping breaches in order to avoid any liability. So with that said, let's talk about ways that you can avoid HIPAA liability, what you need to do to avoid breaches or respond appropriately if there is a breach to avoid any penalties. First, you need to assign HIPAA responsibility to the appropriate officer. HIPAA requires you to designate in writing a privacy officer and a security officer if you are a covered entity. The privacy officer is in charge of making sure that the covered entity complies with the privacy rules. The security officer is in charge of making sure that they comply with the security rules. That designation needs to be in writing. Second, you really need to know and understand the privacy rules. One of the biggest exposures to entities is the requirement that you have to narc on yourself. You have to report breaches of privacy rule violations. But note that the breach notification rule only applies to privacy rule violations. If it's not a privacy rule violation, you don't have to self-report. And therefore, it's important that your privacy officer knows and understands when a breach occurs, when a reportable breach occurs under the privacy rule and when it doesn't. The general rule for use and disclosure of protected health information under the privacy rule is pretty simple. The general rule is this: you cannot use or disclose protected health information. Note that you can't even use it internally, as well as disclosing it outside your organization, without a valid written HIPAA authorization unless. So the general rule is you've got to have a HIPAA authorization to use or disclose that information unless you can fit within an exception. There's generally 3 exceptions that apply. The first is, as long as that use or disclosure is for treatment, payment, or healthcare operations, you don't need the patient's consent, and you can go ahead and provide that or disclose or use that information without the patient's authorization, as long as it's for treatment, payment, or healthcare operations. In those situations, consent is implied. Now, there is an important limitation on that. If you agree otherwise with the patient, so you tell the patient that, hey, even though HIPAA doesn't require us to get the authorization, we're not going to disclose your information without your consent, even for treatment, payment, or healthcare operations, then HIPAA says, hey, if you agree with the patient for that, then you've got to make sure that you comply with that. And if you don't, then that's a HIPAA violation, even though HIPAA would not otherwise require an authorization. My advice is don't agree with the patient to limit your use or disclosure of protected health information for purposes of treatment, payment, or healthcare operations, because you're not required to under HIPAA, and by doing that, you're increasing your HIPAA exposure. Now, there is one limited exception. Under the HITECH Act, and under the Omnibus Rule, there's a new rule that says that if a patient pays for their episode of care themselves, or somebody pays for it on their behalf, then they can come in and tell you that they do not want you to disclose information relevant to that episode of care to that patient's health insurer. The theory there is if the patient paid for it themselves, then the insurer really has no business knowing about that information, and therefore they can tell you not to disclose that information to their health insurer. In that situation, even though the disclosure would be for payment purposes to the insurer, they have a right to limit your use or disclosure of the information for purposes of payment. Now, that's the bad news. The good news is that only is triggered if the patient comes in there and requests that you limit that disclosure, and if the patient or somebody on behalf of the patient pays for that episode of care. That doesn't occur very often because the patients don't realize that they have that right, and if I were you, I would not be inviting them to make that type of a request. You do have to include that information in your notice of privacy practices, but I wouldn't call attention to it, and hopefully your patients won't make that request of you. So that's the first huge exception. That's very important because most of what you're going to use or disclose the protected health information is for purposes of treatment, payment, or healthcare operations. And as long as the use or disclosure is for purposes of treatment, payment, or healthcare operations, and you didn't otherwise agree with the patient, then you don't need the patient's authorization to use or disclose the information for those purposes. Second exception, HIPAA allows you to make certain disclosures so long as the patient hasn't objected. You don't need the patient's written authorization for this, so long as the patient hasn't objected. The first is for a facility directory. So if you have a hospital and you have the pink lady there at the reception desk, somebody comes in and asks for the patient by name, then that person at the registration desk can disclose where that patient is in the facility, disclose their general health information, but they can't disclose more information than is specifically allowed. You can just disclose their name, their location in the facility, and their general condition. That only applies if the patient has not objected to those disclosures. So if the patient wants to be a do not publish, then you can't use that information for purposes of the facility directory. The second exception under this category is disclosures to family members. This is very significant. HIPAA allows you to make disclosures to family members and other persons involved in the patient's health care or payment for their care, so long as the patient has not objected, they didn't tell you otherwise, and that use or disclosure is reasonable under the circumstances based on your professional judgment, and you don't disclose more than is limited to that person's involvement in the patient's health care or payment for their health care. That's the exception that allows you to make disclosures to family members, even though that family member may not directly be involved in the treatment of the patient. The third exception, HIPAA contains a series of exceptions that apply primarily to government function or public safety type situations. These are exceptions that allow you to make disclosures to the extent another law requires the disclosure. If another law requires the disclosure, then HIPAA says, fine, you can go ahead and make the disclosure, just don't disclose more than the other law requires. So, for example, if your state requires child abuse reporting or reporting of sexually transmitted diseases or reporting for treatment of victims of a firearm, those types of things, you can go ahead and make the disclosure under without violating HIPAA. There's another exception that allows you to make disclosures to the extent it's necessary to avoid a substantial threat of imminent harm to a patient. There's other exceptions in there that allow you to respond to subpoenas if certain conditions are satisfied, that allow you to make certain limited disclosures to law enforcement, or that allow you to make disclosures to certain public health agencies, those types of situations. Those exceptions are all found in 45 CFR 164.512. If you are a privacy officer, you need to know how to apply those exceptions. If you are not a privacy officer, when a potential issue arises that may implicate those situations, you need to contact your privacy officer and determine whether or not you can go ahead and make those disclosures as allowed by HIPAA. Now, that's the guts of the privacy rule. If you know those rules, you know 90% of the privacy rule. The omnibus rule did clarify some of the rules or change some of the rules when it comes to marketing activities. I've received lots of questions about this recently, so I thought that I would go over that briefly. The general rule is if you're going to market somebody else's product or market a product, you generally need the patient's authorization. So you can't just use or disclose that for purposes of treatment, payment, or healthcare operations. You need the patient's written authorization to market another entity's services. Now, there are some exceptions to that. If that marketing communication appears in a face-to-face meeting with the patient, or it involves the promotional gift of nominal value, in that situation, you don't need the patient's written authorization. In addition, if the proposed marketing activity is really for treatment purposes, for healthcare operations, or you're describing your own products or services, not a third party's products or services, but your own products or services, then in that situation, that's generally not considered marketing, and you don't need the patient's authorization to engage in those activities. Now, there's a limitation on that, though. If that disclosure is for purposes of treatment, healthcare operations, or describe your own services, but you're getting paid by some other entity to make that disclosure, then suddenly it does become marketing, and you would need the patient's written authorization before you could engage in that. Just be aware that those rules for marketing have changed somewhat, so you need to get with your marketing people and make sure that when they're engaging in these marketing activities that they're also considering HIPAA as well as other fraud and abuse laws. HIPAA also says even if HIPAA allows you to make the disclosure, you can't disclose more than is minimally necessary to accomplish a permitted purpose. That's the minimum necessary rule. Now, that minimum necessary rule contains some exceptions. Most notably, it does not apply to disclosures to other healthcare providers. HIPAA also says that you have to have policies that implement that minimum necessary rule. Among other things, you've got to come up with a policy that identifies a role-based access policy. You've got to identify those persons in your organization that have need to access a particular type of protected health information and limit their access accordingly. So, for example, if you're at a hospital, you may say treating physicians are entitled to access this type of protected health information, but only for those patients for whom they are providing treatment. You may establish that your janitorial staff can access this information, but they can't access this other information. You're supposed to go through and identify the categories of staff that you have, identify the types of information that they're enabled to access, and have a policy that tracks that and limits their ability to access information to which they don't have a right. Now, that's important because if you have one of those snooping cases, or you have a employee that goes in there and looks at patient information there where they should not be, if you can show that you have this role-based access that says, hey, it's a need-to-know basis, this guy shouldn't have been in there, if they were violating our policy, there's a very good chance that you can avoid HIPAA penalties in that situation. Unfortunately, Walgreens was not able to avoid its liability under Indiana common law, but it would still help you in most states avoid even common law claims. I'm not going to go into the privacy rules in any more depth. The bottom line is, if you haven't ever read the privacy rules, it's really time for you to do so. The security rule is found at 45 CFR 164.300 et sec. The breach notification rule is at 0.400 et sec, and the privacy rule is at 0.500 et sec. You really need to take the time to become familiar with the privacy rules. The government maintains a very helpful website. You really need, this can be your best friend when it comes to HIPAA stuff. Among other things, it has FAQs, it has a bunch of guidance concerning HIPAA. If you have questions about HIPAA, this is a great resource to go and get your questions answered. In addition, on this website, if you'll see over there in the left-hand column, the government periodically publishes new information. So in the past year or so, the government has identified issued a bunch of new guidance on different aspects of HIPAA, things that are potentially problematic or are usually problematic. For example, they issued guidance on disclosures to law enforcement. They issued new guidance concerning HIPAA disclosures in the mental health field. Most recently, they issued guidance on same-sex marriage. So if you become familiar with that website, you are linked into that, then you can get that information concerning that new guidance when it comes out. They'll also give you alerts concerning new regulations when those are issued, new enforcement actions. So if you're a privacy officer, this ought to be on your favorites list for your website. Number 3, you need to respect the patient's rights. Remember, HIPAA not only protects the confidentiality of the patient's information, but it also gives patients certain rights concerning their information. Among other things, you have to give them a copy of your Notice of Privacy Practices. That's that document that you have to hand out no later than the first date of treatment. That has to contain certain elements. In the materials I provided to you, I've given you a checklist of those required elements. If you have not updated your Notice of Privacy Practices to comply with the Omnibus Rule requirements, you need to do so. Next, the patient has a right to request restrictions on the use or disclosure for treatment, payment, or healthcare operations. For those of you who are paying attention, you probably realized, hey, I just told you that you don't need the patient's authorization for purposes of treatment, payment, or healthcare operations. That's the general rule. This patient right says, yeah, the patient has a right to request restrictions, but you don't have a right to agree to those restrictions. So you can refuse to place additional rights or limitations on your ability to disclose for treatment, payment, or healthcare operations. Again, my advice is don't agree if you're not required to do so. Third patient right, a patient has a right to request communications by alternative means or at alternative locations. So if this situation, a patient comes in and says, hey, I want you to communicate with me via text or via email, or I want you to send this information to me in a sealed envelope at my work rather than at my home. As long as it's a reasonable request, you have to comply with that. If you're communicating with the patient via email or text, that can create issues under the security rule. I'll talk a little bit more about that a little bit later. Next right, a patient has a right to access their protected health information to obtain copies. Generally, you've got 30 days to respond to those requests, and there's limits on that. A patient has a right to request amendments to their protected health information. Note that a patient only has a right to request the amendment. They don't have a right to have an amendment made. If, for example, the amendment was correct, or the original record was correct, you don't have to amend their record. But the patient in that situation would have a right to have a statement of disagreement attached to their medical record, and it would then become part of their medical record. You've got to respond to those requests for amendments within a certain period of time set forth in the regulations. Finally, the patient has a right to receive an accounting of disclosures that you've made of their protected health information, but not all their information. Only what it boils down to is essentially those disclosures that were made improperly. You've got to track those, and you've got to make that available to the patient if they request it. Note that this is an additional requirement separate and apart from the breach notification rule. Even though you're not required to do a self-report of the breach to the individual, you still have an obligation to account for improper disclosures that were made in this accounting of disclosures. Most patients, patients very rarely ever request that accounting of disclosure. That does not excuse you from maintaining that list of accounting for the disclosure if the request is ever made. Now, it's part of the HITECH Act. The government expanded the requirements under which you would have to give a report if you maintain electronic health records. They actually issued a proposed rule a couple of years ago in which it would require you to, if you maintain electronic health records, to generate a report that shows where the patient's health information has gone, even if it's for treatment, payment, or healthcare operations. That proposed rule has not been finalized. We don't have a final version of that yet. We don't know when that's going to come out. That was not included in the omnibus rule. That's something you may need to watch for in 2015. If you are purchasing an electronic medical record, or you're considering updates, or you're considering the functionality of your electronic medical records, just remember, you may have reporting requirements under HIPAA, under this accounting for disclosure rule. And therefore, you may want to make sure that you include that or consider that in your contract so that you're going to get the updates that you might otherwise need to comply with the new rule if and when it comes out. Number four, the fourth thing you need to do to make sure you're going to avoid penalties is have your written policies to help you ensure compliance. Address the privacy rule, security rule, and your breach notification rule. There are a lot of policies that are out there. Some of them are multiple pages or binders thick. Personally, I don't like those really long policies. My concern with those really long policies are they're so long that people don't really read them or understand them, and then they're just going to be used against you if the government ever comes in and decides to do some kind of an audit. It's not enough just simply to purchase a policy, put it on the shelf, and then forget about it without actually implementing, enforcing it, or periodically reviewing it. The most recent published HIPAA settlement involved a group of Alaska clinics, mental health clinics, and interestingly enough, the government tagged them. They had their policies, but the government said that they had not periodically reviewed or updated those policies. They hadn't included patches in their security system, but as a result of that, their security system was vulnerable to attack, and it left, I think, about 3,000 patient records out there that were visible to people who wanted to search for those types of records. This is one of the first cases where the government has gone after somebody, not because they didn't have the policies, but because they failed to update those, maintain that those policies were effective. So it's not enough simply to have those policies. You need to make sure that you're actually complying with the policies, periodically evaluating those policies and updating those policies as necessary. In the materials I provided to you, I've given you a checklist for policies under the privacy rule, the security rule, and the breach notification rule. If you want to evaluate whether you've got the required policies, you can use that checklist to at least check off that you've got the policy, and then it's up to you to determine whether or not you're really complying with it. If you have not done so, you need to update your policies concerning the omnibus rule requirements that came out in 2013, including the new rules concerning deceased persons, restrictions on disclosures to insurers, selling protected health information, using or disclosing protected health information to market services, access to electronic protected health information, and perhaps most importantly, the new breach notification standard. In the materials I've given you, I've included a checklist for omnibus rule compliance. You can use that to evaluate whether or not you need to update your existing policies. Number 5, in addition to the policies, it would be helpful if you developed compliant forms. HIPAA requires you to have certain types of forms, specifically an authorization, a notice of privacy practices, and business associate agreements. HIPAA contains specific requirements for each of those, and therefore it's important to ensure that those documents comply with the HIPAA policies, the HIPAA requirements. Now, even though there may be a technical violation, the government's probably not going to come in and impose penalties. That's probably not willful neglect unless it's a pretty serious violation. Nevertheless, it's better to be safe than sorry, so I've given you a checklist for HIPAA-compliant authorizations, notices, and business associate agreements. You may want to periodically review your existing forms and agreements against that checklist. As you probably noticed, your forms and policies, your business associate agreements, those have a tendency to morph over time, and it may be that they were compliant when they were originally written, but they are no longer compliant, that they've got more stuff in there than should be, and therefore you need to make sure that you periodically check them against the rules to ensure they're still compliant. Those checklists can also be helpful if you get an authorization or you get a business associate agreement from a third party, and you want to know whether or not that authorization or that business associate agreement you received from some other person has the required elements. You can use the checklist that I've given you to evaluate its compliance. In addition to those required forms, you may want to create other forms that aren't necessarily required by HIPAA, but that are permitted by HIPAA, including a form that allows a patient to request access to their protected health information, a form that allows the patient to request an amendment to their protected health information or request a log of disclosures for their information, or maintain a form that allows you to track improper disclosures. Those aren't required, but sometimes it's a good idea to have those in place. The government has published several different forms on its website that you can use. They recently did a notice of privacy practices. Quite frankly, I am not a fan of the government's notice. I think that it is very pro-patient and does not contain all the protections that you might otherwise want to have. So I guess I'm not a big fan of theirs. I would rather go with one of my own forms or a form that more closely tracks what the regulatory requirements are without adding a bunch of the additional commentary that the government has put in their notice. Number 6, if you are using business associates to perform functions on your behalf, you need to make sure you have valid business associate agreements. A business associate is an entity to whom you give protected health information to perform functions on your behalf. Under the omnibus rule, it includes entities that maintain protected health information. So if you're using a cloud storage vendor or an off-site vendor for your electronic protected health information, HIPAA now is going to apply to them as a business associate. That means they need to be complying with HIPAA, and you need to get a business associate agreement with those entities. You need to execute that business associate agreement before you disclose the protected health information to the business associate. If you fail to do that, then that's an improper disclosure under HIPAA. That business associate agreement has to include certain required elements. I've given you a checklist that identifies the elements that should be in your business associate agreements. Now, those business associate agreements are important because you generally are not liable for what a business associate does. If they screw up with your information, you're not liable unless the business associate is determined to be your agent, meaning that you had the right to control them. So hopefully your business associate agreement is written in an appropriate manner to confirm that that business associate is not your agent. So you're not exercising such control over the business associate so as to make you vicariously liable for what that business associate does. You're generally not obligated to monitor what the business associate does, but if you know that that business associate is out there violating HIPAA or screwing up your protected health information, you need to take affirmative steps to stop that. If you don't, then you could be liable for what that business associate does. The government has issued sample business associate language. They haven't given you a sample business associate agreement per se, but they've given you sample terms that you might include in your business associate agreement. That business associate form that the government has provided does not contain additional terms that most people would want to have in their business associate agreements. So you might consider amending your business associate agreements to add these additional items that appear in that checklist or that are here on the screen. Things like, if you're a covered entity, you want maybe to ensure that the business associate has adequate insurance to cover breaches, or that they are going to indemnify you for breaches that might occur. You might require them to implement certain policies or procedures, even though they aren't necessarily required to under HIPAA, and so forth. Conversely, if you're a business associate, you might want to make sure that your information, your business associate, has information that may not be in the covered entity's business associate agreement, or that is different from the terms that are in the business associate agreement from the covered entity. For example, if the covered entity wants you to indemnify them for HIPAA breaches, if you're a business associate, you don't want to do that, so you may want to take that out. You may want to place certain responsibilities on the covered entity to make sure they notify you of limitations that they've placed on the use or disclosure of protected health information, and so forth. There's a list of items there, and in the checklist I've given you of additional terms you may want to consider in your business associate agreements. Number 7, we're going to start talking a little bit more about the security rule now. One of the things that you're required under the security rule to do is to perform and document a security risk assessment. You need to do this analysis to determine where are your system vulnerabilities, and then you need to implement safeguards to address those situations. This is incredibly important. In some of the cases that came down last year, one of the reasons that they tagged the individuals, the covered entities for willful neglect, was that they had not performed or documented the required security risk assessment. So it's important for you to do that. If you haven't done that, or if you haven't done that for several years, you need to periodically conduct that risk assessment and document it. Fortunately, the government, in order to help you, has given you some tools to help you do an appropriate security risk analysis. There is a bunch of information that's on the OCR's website. More specifically, last March, the government published their own risk analysis tool. You can go to the Health IT government website, and it's got a tool that you can use to perform this risk assessment for you, to help you do this risk assessment. And if you use the government's tool, I think chances are pretty good that the government's going to accept that if they come in there and do an audit to determine whether or not you did an adequate security assessment. Once you've done that risk assessment, you've documented the results, then you need to act on it. More specifically, you need to implement appropriate safeguards. Now, the privacy rule is pretty general. It just says you have to implement reasonable safeguards. You don't have to go overboard. When it comes to the security rule, however, you've got to implement very specific physical, administrative, and technical safeguards that are set forth in the rule. In the materials I've given you the checklist of the policies that you need to make sure that you have. Now, some of those implementations, some of those required safeguards, some of them are required, and for those you have to implement them. Some of them are addressable. That means you don't necessarily have to implement the safeguard that's included, an addressable safeguard, so long as there's an alternative that provides equivalent protection, and there's a reason why you don't apply the addressable standard. In that situation, you need to document that you consider the alternative, that your alternative is reasonable under the circumstances in order to satisfy the rule. A good example of this is encryption. Encryption is an addressable standard. The default is that your electronic protected health information is supposed to be encrypted. But because it's an addressable standard, if you can come up with alternative safeguards that are reasonable under the circumstances, then you don't necessarily have to encrypt. When it comes to the security rule, A lot of people don't like the security rule because of all of the technical requirements, but quite frankly, in this day of cyber attacks, of hacking, of situations where your system may just go down, you really need to comply with the security rule just simply as a matter of business, if not for regulatory compliance. The government has issued a bunch of guidance concerning how you encrypt data, how you protect your data. You can go on the government's website that I've provided to you, and it'll give you additional guidance on how you comply with the security rules. Mobile devices are a big issue right now when it comes to HIPAA security. Everybody seems to have data on their mobile device, and yet they don't think about the HIPAA implications. For example, if you're a healthcare provider and you're emailing or texting health information through your mobile device, well, hey, that's electronic data. That means you have to comply with the security rule with that device, which means that the addressable standard is it has to be encrypted. You would want to make sure that it's password protected. So if you lost your mobile device or you lost a USB or a laptop or something like that, that doesn't result in a fine or penalty. If you've got strong encryption or if you've got password protected, you may be able to avoid HIPAA breaches. On the other hand, if you don't, then that's almost going to be a per se reportable violation and a violation of the security rule requirements. The government has issued this website, this whole tool, this resource to help you evaluate HIPAA implications relevant to your mobile device. If you haven't looked at that, I'd encourage you to take a look at that. We talked about a little bit about the security rule and encryption. As I mentioned, in the wake of that Anthem cyber attack, there's a lot of chatter about, well, should we make encryption not an addressable standard but a required standard? You'll want to watch for that over the next little bit. I mentioned to you that there are situations where you may want to communicate with your patients via email or text. Now, most of the time, information sent out over email or text is not going to be secure. That means that it's supposed to be encrypted. If it's not encrypted, then it's insecure, and you're not necessarily complying with the security rule. In the Omnibus Rule commentary, people asked, well, does this mean that we can't communicate with patients via email or text? The government came back and said, you can do that because, remember, one of the patient's rights is they have a right to request being able to communicate with you by alternative means or alternative locations, including email or text. So the patient could request that. In that situation, the government said, yeah, that's fine. You can communicate with the patient via email or text if they request it, but you need to make sure that you warn them that that communication is not necessarily secure if it's not encrypted. So you can communicate with patients via unsecured or unencrypted email or text, but just make sure that you notify the patient, and if the patient still wants to receive it via unencrypted methodology, then you can go ahead and do that. All right, once you've got all the policies and procedures in place, then the next thing that needs to be done is you've got to train your workforce. You have an affirmative obligation under HIPAA to train your own workforce members, your own employees, your own practitioners, volunteers, and the like. In addition, you have an obligation to provide periodic retraining if there are a change in policies or in responses to violations or the like. You need to, when you're doing that training, make sure that they understand the policies and the principles. You may want to use your Notice of Privacy Practices, which is a good summary of how you're going to protect patient information. You can use that in the training, and make sure you document the training so that if there ever is a question about whether or not this employee went rogue, you can come back and say, hey, we provided the policies, we provided the training, this guy just went rogue, so we didn't act with willful neglect. However, when you do that training, it's not enough just simply to provide the training. You need to follow up. You don't want to be in a situation like Walgreens where they provided the training but may not have followed up closely enough to ensure that there was no violation going on. So just providing the training, just having those policies may turn out that's not enough. Make sure that you're really effective. If you do have a breach, it's very important that you respond immediately. Timely response is important for 3 reasons. The first is it's simply required under the privacy rule. You're required to mitigate a breach. In addition, if you act promptly, you may minimize a risk that the data is compromised and therefore avoid breach notification requirements. I'll talk about that in just a minute. The third is As I mentioned at the outset, you may avoid HIPAA penalties if you do not act with willful neglect and you correct the situation within 30 days. So if you respond immediately within that 30 days, you document that you took corrective action, you may be able to avoid any penalties, even if there was a violation of the privacy rule. Therefore, you need to train your employees to report immediately. You don't want them to sweep this under the rug, because if they report immediately, you may be able to avoid any penalties or harmful effects of that breach. If there is a breach, you need to make sure that you put in place appropriate sanctions against workforce members. That could be some kind of disciplinary action. It could be termination, but it doesn't have to be. But you'd want to document you took appropriate sanctions, and you document your other actions that you took in response to a breach. If you think that there is a breach where the information has gone someplace else, you need to take immediate action to stop or disclose or retrieve the PHI. Sometimes I get calls, people will say, well, we had this breach, and I'll ask them, well, what have you done? And they say, well, nothing. You need to take action. If you think that this information went to some other party, then contact that party. Make sure that they have not disclosed the information to anybody else. Make sure that they're not going to do that. You might remind them of the criminal penalties that may apply to them if they do disclose it improperly. You'll want to take steps to get the information back. By doing that and documenting it, that might help you avoid the risk that it's a reportable breach or mitigate any harmful effects. When you talk to that person who received the information, confirm the scope of the breach. Identify those who may have received the information, the type of information involved, confirm that there were no additional redisclosures, or if they were, track it down so that you can contact those people who got the information improperly, and you can document that you put a stop to any further redisclosures. You should obtain confirmation that the recipients that they do not and will not further use or disclose the information. You can do that orally, and I always like to send a letter to those people who may have gotten the information improperly, something to the effect of, hey, thanks for bringing this to our attention. As we discussed, this confirms that you have not disclosed that information further, that information is confidential, and you will not disclose it further. By the way, the criminal penalties can apply if you did. Thanks. Have a nice day. And you'll want to document those efforts in writing so that you can show the government that you took appropriate corrective action if there was a breach and they're investigating it. Now, some people may say, well, if we correct the situation within 30 days, we can avoid the penalties, but how do you correct a breach when it's already gone out? How can you unring the bell? Well, fortunately, HHS interprets corrected very broadly. They give the following example. For example, in the event a covered entity's or business associate's non-compliant, inadequate safeguards policies result in an impermissible disclosure, the disclosure violation itself could not be fully undone or corrected. However, the safeguards violation could be corrected in the sense that the non-compliance policies and procedures could be brought into compliance. So even though you can't unring the bell, you still may be able to correct the situation by sanctioning the employee, by taking steps to mitigate the disclosure, by putting in place new policies or procedures and providing new training. Number 11, if you conclude that there was a reportable breach, then you are going to have to do an appropriate report. HIPAA requires that if there is a breach of unsecured protected health information, the business associate has to notify a covered entity, and if the covered entity has information, the covered entity must notify the patient or their next of kin. They've also got to notify the government. They've got to narc on themselves to the government, and if the breach involves more than 500 persons, they've got to contact local media. You should have a written policy that outlines your breach notification obligations and the process you go through for responding to a breach to help you address those issues when a potential breach occurs. You need to document the breaches, your evaluation, and response. How do you know whether a breach is reportable? Under the breach notification rule, here's the standard. The acquisition, access, use, or disclosure of protected health information in violation of the privacy rules is presumed to be a breach. So it is a breach unless you can demonstrate that there is a low probability that the information has been compromised based on a risk assessment of the following factors. So these are the factors you would analyze to determine whether or not there was a reportable breach, whether there's a low probability that the data has been compromised. First is the nature and extent of the information involved. Did it involve things like Social Security numbers or simply a name with no other information? Second, who received the information? Was it another physician who is going to keep the information confidential regardless, or did it go to some other person who isn't bound by HIPAA who may blab it to others? Third, whether the information was actually acquired or viewed, or whether they simply got it but never viewed it. Fourth, the extent to which the risk to the PHI has been mitigated, to the extent to which you've contacted that person, you've stopped further redisclosures, you've limited the scope of that. All of those factors go into determining whether or not a reportable breach has occurred. If you do that, if you've gone through that analysis and you conclude that there's a low probability that the data has been compromised, then you don't have to report the breach to the individual or the government. On the other hand, if you cannot demonstrate that there's a low probability that the data has been compromised, then you have an obligation to report the breach. If you're reporting the breach, it has to go to the individual no more than 60 days from the date of discovery. That means that you can't wait till the end of the 60-day period to make the report. You've got to report it as soon as possible, but no longer than 60 days. So if you can conclude that investigation within a week, you need to report it at the end of the week. That report has to go by mail to the individual, unless the individual agrees to receive it by email. It's got to contain certain required elements for the breach notification rule that specifies that what you have to conclude in that notice to the individual. If you're going to notify the individual, you're going to have to also notify HHS. The only difference is the timing. If the notice is going to go to HHS if the breach involves less than 500 persons, you can wait until 60 days after the end of the calendar year. So if you discover a breach today, you could wait until March 2nd of 2016 to do the breach report. On the other hand, if the breach involves 500 or more persons, then you've got to report immediately. You do that report by going to the government's website, and as part of the new website, the government has got a new breach reporting portal. The new portal requires some additional stuff that wasn't in the prior portal, but you can go to that website, you can take a look at that. If you have not spent time on that website, you may want to do so that you get an idea of the type of information you're going to have to report if there is a reportable breach, so that you can track that in the event you're going to wait to do the report by the next year. Finally, you need to maintain the required documentation. HIPAA generally requires you to maintain any documents required by HIPAA from 6 years from the last effective date. So if your notice of policies and procedures, the last effective date that it was in effect was yesterday, you've got to keep it for 6 more years. That applies to all of those documents that are up there on the screen. Finally, remember that HIPAA, again, is the floor of patient privacy, but to the extent that there are more restrictive state or federal laws, you've got to comply with those more restrictive state or federal laws. Also remember that HIPAA not only applies to healthcare providers, but it also applies to employee benefit plans if it is administered by a third party or has 50 or more participants. You probably have HIPAA policies in place for you in your capacity as a healthcare provider, but also remember that you also have to have HIPAA policies in place to the extent that you are an employee benefit plan. That employee benefit plan has to have essentially the same types of things that apply to covered entities. So HIPAA really hasn't to date been enforced against employee benefit plans, but there's a potential that it could be, so just be aware that if and when the government starts going after people for that you need to make sure that you've got those policies and procedures in place. For additional resources, okay, that is my summary of what you need to do in 2015 to avoid HIPAA penalties. For additional resources, there's a bunch of stuff on that HHS website, the OCR HIPAA website. I would encourage you, if you're not familiar with that, to spend time getting familiar with those resources. Among other things, it's got a good audit protocol. This was based on the original audit protocol. We haven't received the updated audit protocol, but the posted protocol on their webpage does give you a pretty good checklist of issues that you may want to evaluate if you're analyzing your HIPAA compliance. If not, I provided you a bunch of other checklists that you can use. We also have a bunch of resources for free on our website, including prior webinars on different HIPAA-related topics. We've got a version of sample HIPAA documents that were updated to comply with the HIPAA rules. If you're interested in obtaining those, you can contact me. If you have any questions concerning anything that we've talked about today, feel free to send me an email, shoot or respond to the chat feature. Otherwise, that is it. I appreciate your participation always in these programs, and I hope you guys have a good week and good luck in 2015 with HIPAA.